beginning in the mid-1980s, and Mr. Abu-Ghazaleh talked about the Uruguay round and how that resulted in an agreement signed last year. By the way, I should say, I hope no one was expecting me to speak Arabic, because I'm afraid you will be disappointed. But if you have trouble understanding me, please raise your hand. I'll try not to use any terms that are jargon. The United States fought very hard and against a lot of opposition to say the world trading system must go beyond merely covering and establishing rules for trade in goods. We must cover trade in services. We must cover trade in intellectual property, because, as I said earlier, that's where our comparative advantage is now. That's where economic growth is for the United States. I'm sure you're all aware the United States has a number of trade issues that it raises with its trading partners, such as Japan, such as China. Although obviously we defeated Japan in World War II, there are those who say, well, the United States won the war but lost the peace, because the Japanese came and they have now a third of our automobile market. There's not a television or a VCR that's manufactured in the United States anymore, or there are some now, but there are actually Japanese companies who have established factories in the United States. So what are you doing? We say our economy has moved beyond trade in goods in many cases, but we do have a comparative advantage, as I said, in certain industries such as pharmaceuticals. And in fact, not only do pharmaceuticals have a trade surplus in the United States, we also have a trade surplus with Japan. And we are the only high technology in the manufacturing industry left in the American economy that has a trade surplus with Japan. So the Uruguay round resulted in what we call, as Mr. Abu-Ghazaleh explained, TRIPS, trade-related aspects of intellectual property protection. For my industry, the TRIPS agreement is a bit of the classic good news and bad news story. What's the good news? The substantive standards of TRIPS are in fact quite good. They eliminate discrimination for intellectual property protection by field of technology. And that sounds a bit academic, but what do I mean by that? I think you can all guess. Countries will eventually have to change their patent laws to cover all types of goods. Here in Jordan, in many other countries, not just in the Middle East, but in Asia and elsewhere. Pharmaceuticals, agricultural chemicals are specifically excluded from patent protection. That's no longer acceptable. It requires a standard 20-year term. It closes basically loopholes. Pharmaceutical patent protection, as in patent protection for most technologies, is only as strong as the proverbial weakest link in the chain. There are any number of loopholes through which pharmaceutical patent protection can be undermined. One of them is having too short of a term. One of them is requiring or having various conditions under which the government can license your technology to your competitors. One of those ways is to say, well, you're required to work the patent. A patent, after all, is somewhat of a deal. It's a bargain between the inventor and the government, and by extension from the government to the people and the economy. The patent protects the inventor for a limited period of time from copying. In return, the patent holder makes public his invention, and thereby encouraging the inventive and the inventive process, new innovation. Somebody can say, well, that's interesting, let me see if I can improve on that invention. But also, by getting a patent, you are required to make use of the invention. A patent is not a guarantee to someone who can say, well, I can sit on this, I'm going to hold on this, I have exclusive rights to this invention, and I'm going to decide when I take it to the market. You have to make it available for people to buy and to use. Some countries have said, well, unless you make the product here in my country, you're not really working the patent. Well, for those of you who are in business, you know, it's absurd to think that you have to establish a manufacturing facility in every single country in which you want to do business. You simply can't do it. So the very fact of importing the product is clearly defined in the new TRIPS agreement as satisfying patent working requirements. That's the good news. Now the bad news is they say, okay, I said that TRIPS eliminated discrimination in terms of patent protection, but it did discriminate against one industry, and regrettably that's mine. They say, okay, the good news is you have good standards. Now the bad news is you have to wait for 10 years. And it's actually worse than that. The concept of pipeline protection. You'll recall a few minutes ago I described that in terms of the inventive process for pharmaceuticals, the patenting of the molecule takes place fairly early in the inventive process. However, it's a good 8 to 10 years before that molecule becomes a medicine and is approved by health authorities and is made available to doctors to give to you when you're sick. So in other words, a patent on a new medicine that is granted today in 1995 will likely not come to the market until approximately 2005. So if a country waits to change its patent law until 2005 and says only patents granted after 2005 will be protected under our new law, that in effect means that there will be no impact of pharmaceutical patent protection in that country until 2015. And I hope that we can discuss that a little bit later, because as I mentioned in my introductory remarks, I think that there's a lot of misunderstanding. I think there's a lot of overemphasis on the negative, and I think that the idea that just TRIPS itself is somehow going to change